excellent segue to what I'm now going to tell you all about, which is how to structure your employment arrangements in a way that will hopefully avoid you ending up being in court with a dispute, which is somewhere that no one really wants to be apart from lawyers typically. I've been told that people can generally remember sort of 3 to 4 things at any given time. I'm going to push you a little bit this morning and get you to try and remember 5 that all fits on one hand, so hopefully that will help. And like I said, they're all tips really to try and stop you getting to that stage when you're in court and trying to defend a matter. So getting it right at the start of the arrangement or the agreement that you're entering into with someone. The very first tip relates to avoiding any disputes that might arise as a result of those pre-employment negotiations that you're having with someone. And this is that stage where you might be trying to sort of entice them over from where they are at the moment. You're telling them all about why your organisation is fantastic and they should want to come and work with you, which can land you in a bit of hot water if subsequently the relationship breaks down and you're in a position of having a breach of contract dispute with that employee. There's a risk that they might say those discussions that we had before I signed up and became your employee included some verbal terms which were then incorporated into our employment agreement. And unless you're assiduously taking notes when you're having those discussions, you're then in a position of having your version of events being directly contested by this person, and it's one person's word against another. So you preferably don't want to be in that position of having possible verbal terms to your employment agreement. The other reason that this is important is to avoid any claims for breaches of Australian consumer laws. So those laws really prohibit any misleading and deceptive conduct. They also prohibit particular misrepresentations around employment terms. We're starting to see more of those sorts of claims arising. They tend to be tacked on to a bit of a shopping list of claims that are made in court proceedings by former employees. So you can see them arise if there's a breach of contract claim, like I was referring to earlier. A discrimination claim, they might add on a misleading and deceptive conduct aspect to that. A general protections claim under the Fair Work legislation. So a way that you can quite easily avoid this from arising or put yourself in a better position if it does subsequently arise is to use what's called an entire agreement clause in your employment contract. And that's a clause that quite simply says this contract is the agreement between the parties. Any previous discussions that were had, arrangements that were entered into, representations that were made don't form part of that employment relationship. So as part of your documents that you use, we'd really recommend that you include a clause like that generally. Tip number 2 is just to be very careful if you're referring to any policies in your contractual documents, making sure that those policies themselves haven't been incorporated into the contract. Policies are a fantastic thing to have. I recommend you do have them. They're good just to clearly set out what the expectations are on both sides of an employment relationship. They're also very important if you find yourself in a position of being involved in a discrimination matter or a sexual harassment matter. So if one employee makes a complaint against another, you as an employer can be held to be vicariously liable for your employee's behaviour unless you can show you've taken reasonable precautions to prevent it arising. So it's quite important to have policies on matters like sexual harassment to be setting those expectations really clearly from the beginning of a relationship. An issue can arise though if your contracts refer to those policies and don't make it clear that they're not incorporated. That arose in that Goldman Sachs and Mikulich case. Mikulich was a financial advisor for Goldman Sachs. He subsequently was bullied at work. He developed a pretty serious depressive illness and was terminated from his employment. He then brought proceedings in the federal court against Goldman Sachs saying, I had this policy that you gave to me when I joined up with you. It was I think a 120-page document. Had a whole lot of employment terms and conditions in it, and he said that document itself formed part of my contract, and Goldman Sachs, by not complying with the terms of that document around how grievances would be dealt with, providing a safe working environment for employees, you've breached my employment contract. The court agreed and awarded around $500,000 worth of damages to him, so pretty substantial award there, and really just shows it's pretty important to get that right at the beginning. The tests that the courts look at when they're deciding is this policy incorporated in the contract or not was set out in that Nikolic decision and also in the Riverwood decision, which is a slightly earlier one. The main factor that they'll look to are what the contract says about the policies. Is it clear that they're intended to be binding on both parties? And what do the policies themselves say? So if the policies are expressed in just sort of aspirational language, this is what we endeavour to do, goals rather than something that's set in stone, less likely to be a contractual term. If it's something though that's promissory or it's obligatory in language, there's a real risk it could be contractual. The way to try and avoid that is just to be very clear in the contract itself that policies need to be complied with, they're a lawful and reasonable direction of the employer, but they do not themselves become a binding term or impose any entitlements on the employee. This tip is around post-employment restraints. I'm not sure if there's something that typically arise in your industry. Are any of you subject to one yourself, or do you use them in your organisation? You do? As a sort of general rule, they're unenforceable. Courts don't like them. They seem to be a bit unfair that they're stopping employees from being able to go and use their skills and trade to earn money for themselves once they leave their employment. They are more likely to be enforceable, or they only will be, if they can be shown by the employer to be reasonable and be going no further than is necessary to protect the employer's legitimate business interests. That's things like, well, it depends on the business itself and what your interests are, but for an accounting firm, for example, it would be your trade connection with your clients, your customer connection. If you're in a business where that relationship is critical to how you get work, that it's all about sort of the relationship that the client has with the individual. If they're someone that's out there really getting work and bringing it in and keeping it, then it's more likely to be reasonable. But you need to make sure the restraint itself is not going further than is necessary to really protect that interest. The way that you can make it more likely to be enforceable is to use what's called a cascading restraint, which is why my secretary Joanna has put a beautiful photo of a cascading waterfall for us on that slide. And they can cascade in a couple of ways. One is to make the period of time that the restraint applies cascade down. So you start with a longer period of time. You might say for 12 months after the employment, you can't solicit our clients and our employees, and you can't compete with our business. If that period of time, though, isn't regarded as reasonable by a court, then you can't do that for 6 months. If that's not regarded as reasonable, you can't do that for 3 months. The other way you can cascade those clauses is through the area that they apply to. So if you've got operations throughout Australia, and that person is a key client contact for clients across the country, you might say this restraint applies throughout the country. If that's not enforceable, it applies in Victoria. If that's not enforceable, it applies within metropolitan Melbourne. And that really gives the court an option, if they regard that clause as being too broad, to read it down so that it's still enforceable on some level, so it gives you a bit of protection there. One thing to be careful about, though, is that you don't have so many levels of sort of permutations and possible combinations that the clause just becomes ridiculous and impossible to understand what it really means. So I think there were some cases where they had those cascading periods of restraint and areas, and also cascading activities that were restrained, and it was something like 40,000 possible combinations that you could have by combining all of those, which no court or no judge is going to sit there and work out which one of them is reasonable and which one isn't. So keep it simple, but give them a couple of options. Tip 4 is just to make sure, if you do have an employment contract with someone, which I suggest that you do, you make sure you include a clause in there around the period of time that you need to provide of notice of their termination. If you don't include a period there, the court will imply a reasonable period of notice. What's reasonable will depend on things like their length of service, their seniority, their skills and qualifications, how long it typically takes someone with that role to find alternative employment. So if they're a CEO of a massive company, you'd expect it might take them much longer to find an equivalent role elsewhere than if they were a junior accounts clerk. So in those sorts of circumstances, courts can imply a term of 6 to 12 months notice, which might be more than you're in a position to be able to provide. So important to make sure you're expressing the document about what that notice is, and that it's at least as long as the minimum periods that are set out in the Fair Work legislation, which is that quite chunky book on the table there. The periods that are required under the legislation vary depending on your length of service. So I think at the lower end of the scale, it's 1 week for less than a year's service, up to 4 weeks if you've got over 5 years service. You should make sure that the clause doesn't require notice to be provided in the event that the employee engages in serious misconduct. There's an exception under the legislation in those circumstances. And serious misconduct is really things on that upper end of the scale of misconduct, so dishonesty, theft, violence in the workplace, some form of sexual harassment, things of that sort of quite serious nature. And quite self-interestedly, I'd always say get advice as well before dismissing someone. Even if you are doing it with notice, there might be a risk that they're covered by unfair dismissal laws. There might be a discrimination aspect to the reasons for the dismissal. So even if it's just calling up Fair Work Ombudsman helpline or calling someone that you know, good to bounce that off someone before you sort of pull the trigger. And finally, it probably goes without saying, but just make sure you comply with your legislative requirements in your contractual documents. The Fair Work legislation has got 10 national employment standards, which are minimum standards that you just can't contract out of, which are up there on the slide. There are things like leave entitlements, notice of termination, which I was speaking to, rights around flexible working arrangements if you've got young children or you're returning from parental leave, and also some entitlements to redundancy pay. So there's no need to actually set all of these entitlements out in your contracts, but make sure that you don't have any clauses that are inconsistent with them. There's also requirements under the legislation about how frequently you pay employees. If there's no bond award or enterprise agreement that applies, it needs to be at least monthly. And there's also provisions around when it will be permitted to make deductions from employees' pay. I think that often comes through as a bit of a surprise to employers, that you can't just deduct amounts that are owing or overpayments that have been made. You actually need employee authority in writing, and it needs to be principally for their benefit. So make sure that you haven't got any clauses that have crept into your contracts that might contravene those provisions. It's important to state in the contract that any benefits that you're providing that are also payable under legislation are being paid in satisfaction of those obligations, so that you don't fall into a situation where there might be a claim under both legislation and the contract, sort of a double dipping scenario for the same entitlement. You need to make sure that none of the terms in the contract could be arguably discriminatory. So, for example, you might have an arrangement that every week we have meetings at 8 p.m. on a Thursday night, which could indirectly be discriminatory against someone that's got family responsibilities and needs to get home and look after their kids. That might be reasonable in some circumstances, but it may not. And finally, on the legislative requirements point, be careful if you are referring to legislation that you're not paraphrasing it. You might slightly incorrectly describe what the obligation is, which again leads to that risk that someone might say, you owe me this entitlement under both legislation and under the contract, which is described it slightly differently. Now, I'm very sneakily sort of slipping in a sixth tip here. But just an issue that I thought was quite important, and it picks up on the point that you raised about contractors. I'm not sure if any of you engage contractors generally. You all do. I thought it would be pretty common in your industry. There's a risk that arises often when everyone, including the contractor, is describing this relationship as an independent contractor relationship, but in actual fact they're an employee and they'd be regarded by a court as an employee. I think there was a Justice Gray decision where he said it doesn't matter if you call it a rooster, it can still be a chicken. So you've got to really look at what are all of the incidents of this relationship and is it an employment relationship even if we're calling it something else. Courts apply what's called a multifactor test, which is not a very creative name, but looks at a number of factors in this relationship between the parties. The most important one that they'll consider is control. So if the principal or the employer, depending on what we decide they are, can exert a very high degree of control over the way that the worker carries out their duties or performs the services, they're much more likely to be regarded as an employee than an independent contractor. The other sorts of factors that they'll look to are the ability to delegate work out. So if you contract with someone, they can then subcontract to others, they can employ their own employees to do the work. That's looking more like a true contracting relationship. Similarly, if they can themselves perform work for other organisations, it's much more likely to be regarded as a true contractor. They're able to build that business for themselves. In contrast, if you've got someone who you're able to control the hours that they're working, how they're performing the role, when they'll be in the office, it's much more an employment type relationship. The other things that tend to be considered are how you're paying the person. If you're paying after invoices are submitted, which I think was your example, much more likely to be considered a contractor, particularly if it's through a company, they've got an ABN. There's that level of separation between the organisation and the individual, which is a good position to be in. So just really critically think about that relationship at the start and work out whether this is really likely to be regarded as an employee or not. The implications of getting it wrong are quite serious. Not wanting to do that scaremongering that Annabelle was talking about, but legislative entitlements to leave, access to unfair dismissal laws, all of that will arise if they should be regarded as an employee. There's also the risk of prosecution for breach of the sham contracting provisions of the Act. I'm not sure if anyone's had any awareness of those before. They're provisions that prohibit essentially misrepresenting to someone that they're a contractor when in actual fact they're an employee. There's civil penalty provisions, so quite serious financial fines can be imposed if you breach them, and it's just not a good look generally as well. So try and avoid that if you can. Not to leave on a sort of Debbie Downer note, but typical lawyer trying to drum up work, he'll get you to get advice if you need to.